Americans for Prosperity North Dakota proudly supported important policy improvements that broke barriers for all North Dakotans this legislative session. From tackling unnecessary and burdensome occupational licensing standards to fighting for tax relief, AFP is proud to have played a part in improving the lives of North Dakotans this year. Join AFP today by visiting www.afpnd.org. This advertisement was paid for by Americans for Prosperity. Welcome to the Plain Talk Podcast. I am your host, Rob Port. Coming up a little bit later in the show, Attorney General Wayne Stenehjem is going to be talking about a process through which a streamlined process. It's a process that already exists in the state of North Dakota. There's a board that meets regularly to make recommendations on pardons to our state governor. And essentially what's going to happen is this board, this commission, this committee, I'm forgetting what it's called now off the top of my head, but essentially it's going to streamline the process so that folks who may have been convicted in the past of petty marijuana offenses, they can basically make a very easy application, or much easier than it is currently, application to the board to have those offenses pardoned, which is even better. You know, in the past we have talked about expungement. That was part of the Measure 3 ballot measure on the ballot in North Dakota here last year, which included an expungement provision, which is merely a sealing of records, which is of dubious utility in this era where, you know, a lot of these records are online, and, you know, once that stuff is online, it never really goes away. A pardon really does mean, you know, the crime goes away. I mean, in a very legal sense, although, you know, the fact that you were arrested and convicted of a crime, you know, may still be out there. Legally, you could say, I have not been convicted of a crime. Now, the intent here is to help people who, you know, may have been, you know, convicted of a petty marijuana-related offense in the past, but going forward, you know, it would clear the way so that it's easier to get jobs, easier to get housing, things like that. So very interesting interview. That's coming up with Attorney General Wayne Stenehjem. Before we get there, though, there's a couple of things that I want to talk about. First, there was a report from Jack Dura, Bismarck Tribune reporter Jack Dura, although it was reported to publications across the state. Very good report. I'm glad he reported it. Essentially, he went through and he saw, you know, how many absences state lawmakers took during the legislative session, and also how much pay they collected. Because one thing that state lawmakers do is it's sort of an automatic thing. If you ever watch floor sessions in Bismarck, you know, a lot of times at the end of the floor session, they'll just do this routine vote to excuse absences. And by excusing those absences, they guaranteed pay for everybody who's not necessarily there. So what Dura did is he went through and he found that absent lawmakers collected around $56,000 in pay during this most recent 2019 legislative session. That means pay for days that they were not in during the floor session. Now, that's the important part. They weren't there during the floor session. A lot of times, these lawmakers may have been there during, you know, committee hearings or whatnot earlier in the day. They just weren't necessarily there for the floor sessions. And sometimes the floor sessions don't have a lot of important business going on. And sometimes if the weather's bad, lawmakers will leave early. I'm not making excuses for these guys, but sometimes, you know, they'll leave early and they won't necessarily attend the floor session because there's nothing really important going on during the floor session. They were there for all the committee work. They just didn't show up for the floor session. I don't know that that's necessarily a big deal. But what was interesting to me, because there's sort of been the usual Sturm und Drang about, you know, these politicians and they're not showing up for work and we're paying them money. And trust me, if they weren't showing up for work for a good reason, then yeah, I'm going to be angry too. But Dura's report, you know, he went and he looked at 5 lawmakers who missed more than 10 legislative days. So these are the people who missed most of it. They represent about a third of that $56,000 in pay for absences that we're talking about. The reasons why seem pretty credible to me. Representative Dick Anderson, a Republican from Willow City, missed 11 days due to hip surgery. Representative Dwight Kiefert, a Republican from Valley City, missed 19 days because he had cancer. Representative Emily O'Brien, a Republican from Grand Forks, missed 51 days. She was pregnant and she gave birth, and then she had some resulting health issues, and she ended up missing a lot of the legislative session. Representative Robin Wise underwent back surgery, missed 2 weeks, 14 days. Senator Arnie Osland, Republican from Mayville, missed 16 days. He ultimately resigned, but he missed 16 days. He had a stroke. Now, I know these days it's fashionable, it's en vogue to be, have this populist rage and have this very cynical attitude about politicians, but the thing is that these people are human beings too, and serving in North Dakota State Legislature does not exactly earn you a financial windfall. This last legislative session, lawmakers were paid $495 per month. Now, they get paid that throughout the 2-year cycle. They get paid that throughout their term in office. That's their, basically, I guess you want to call it their salary, $495 per month. Now, when they're in session, on top of that, they get $177 per day. That's, the months, it's no more than 80 days as constrained by your state constitution. But when they go to Bismarck and they actually meet during the legislative session. But you can't forget, they also have to go to interim committee hearings. Those happen regularly, at least once a month for these lawmakers, where they have to travel from their homes to Bismarck for legislative meetings. They have to keep up. Legislators have to, obviously listen to, the city governments, the county governments that are in their legislative districts. They have to meet regularly and attend those meetings on a regular basis. They have to meet with constituents. They're expected to go to constituent events. They're expected to go to town hall events. There's a lot of expectations that we put on our lawmakers, and they don't really necessarily have a lot of resources to handle all that. I mean, yeah, they get expenses, they get mileage and things like that, but also they don't have a staff, unlike other states. They don't have, somebody who can help them organize, somebody who can help them interact with constituents. Heck, most of these state lawmakers have, if you look on the legislative website, a lot of them have cell phones and home phone numbers listed. That's a pretty special thing. It, to me, speaks to a culture of public service which exists in the legislature. Now, pay for lawmakers is going up a little bit. As of July 1st, legislative pay went to $505 per month, a $10 per month increase. Their per diem during the legislature has gone to $181 today. It's still a pittance. They really don't make that much money. And frankly, if anything, I think they ought to be paid more. Because here's what happens. If you start getting too tough about lawmakers with, excusing absences and we're going to deny them pay because, they had cancer or something or we're having a baby, or if we, get a situation where we're cutting their compensation down to the bone, the only people who are going to be able to afford to serve in our legislature, which by the way, again, requires that you take months off from your life and career every 2 years to go serve down in Bismarck, not to mention campaigning, not to mention, the interim committee hearings, not to mention, meeting with all the local officials and everything in your legislative district. The only people who are going to be able to afford to do that are rich people or retired people. Do we really want to limit the pool of potential public servants who could serve in the legislature by that much? I don't think that we do. But that's what we do. If we start getting uptight about legislative compensation, that's exactly the outcome that we're going to achieve. We're going to have a group of people who could be very good state lawmakers, who could be very good public servants, very dedicated people who can't serve because they can't afford to. By the way, some of our legislative districts are absolutely huge. I always think of State Representative Keith Kempenick and his, two fellow representative and fellow state senator serving over in District 39 in the far southwest corner of the state of North Dakota. That legislative district, if you look at it on a map, is roughly the size of Connecticut. Now, dotted throughout it touches on counties, it touches on cities, and those lawmakers who represent that area have to cover that entire area. They have to cover it when they're campaigning. They have to cover it when they're representing that area in office. They have to, be responsive to those city commissioners that are in their legislative district. They have to be responsive to all the constituents that live in that area. It's an area the size of Connecticut. And again, they have no office budget, no staff, nothing. So yeah, if we had state lawmakers who were egregiously violating, egregiously abusing these automatic excuses, from legislative days during the session, then okay, let's get after them. but it's only an 80-day session, and I don't, frankly, for the pittance of money it is. Again, this last legislative session, total compensation for state lawmakers was just north of $3 million. We're talking about roughly $56,000 in pay that was excused for lawmakers who were absent. It's not that big of a deal. It's not that big of a problem, and the lawmakers have to consider, hundreds and hundreds of bills during a very, very rapid, again, constitutionally constrained 80-day session. I don't know how much time I want to have them spend on investigating these absences. Because here's the thing. If you think your lawmaker's not doing good enough job showing up for work, well, you have the power of the ballot box to do something about that. The other thing I wanted to talk to you before we get to the Attorney General is traffic fines. Now, in North Dakota, typically, if you get a ticket, it doesn't really matter which state agency was writing you that ticket. They could not exceed the state's level for fine. So if it was, say, an expired registration, that currently will cost you, that's a $20 fine. Now, the thing, though, is that the legislature, this legislative session, it was a bill, Senate Bill 2304, becomes effective in just a couple weeks, August 1st. It will allow cities to treat traffic offenders through their law enforcement agencies differently than if that traffic offender was caught through a state law enforcement agency. So, again, for instance, an expired registration tag would cost you $20 in state district court, like if North Dakota Highway Patrolman issued you the citation. It would cost you $40 in Bismarck Municipal Court if the city of Bismarck does, as the Bismarck Tribune has recently reported, impose traffic fines that are double what state law provides for. Now, the legislature cleared the way for this. Again, Senate Bill 2304, which becomes effective on August 1st, cleared the way for this. Now, the problem, though, is it creates a situation where your responsibility, your punishment, I guess, for violating certain types of laws, traffic laws, would depend on the uniform the person is wearing who issues you the ticket. If it's a highway patrolman, it's one price. If it's a Bismarck City police officer, or eventually I imagine other cities would follow this lead, so a Grand Forks or Minot or Dickinson or whatever. If it's a local police officer, well, then your fine might be significantly more, maybe as much as double, which is what Senate Bill 2304 allows for. It allows for up to 100% more than, no more than double what the state fine is. Now, the thing is if we need traffic fines to go up, well, then fine, we can have that debate. And maybe we do need some of our speeding fines or whatever to go up. A lot of people have made that argument about North Dakota in the past. Our speeding fines are very low here. Maybe we do, in fact, need those to go up. But I don't think we want to get into a situation where we have a city that's just juicing their fines. Because then I think we're creating a situation where it's almost policing for profit, where the motivation is not so much traffic safety, but revenue. And also, I mean, speeding in Bismarck, if you get picked up by a Bismarck police officer, should not cost you more than if you get picked up by a state highway patrolman or a county deputy. I mean, remember, all of these law enforcement agencies have overlapping jurisdictions, right? The county jurisdiction overlaps with the city jurisdiction. The highway patrol's jurisdiction overlaps with both. So that's not such a good situation. Mark Fries, who's a attorney based out of the city of Fargo, works for the Vogel Law Firm. He has a guest post at sayanythingblog.com talking about this. He says that it's unconstitutional, and he says that this is almost certainly going to bring legal challenges. We'll see what happens with that. My interview with Attorney General Wayne Stenehjem up next. This episode of the Plain Talk Podcast is brought to you by Energy of North Dakota. Oil and natural gas from North Dakota strengthens all of America. And through our abundance of talents, innovations, and technologies, energy responsibly produced here translates to worldwide economic stability. With producers and our communities working together, we're securing a sustainable future that generation after generation can build on. It's all happening right now with Energy of North Dakota. Learn more at energyofnorthdakota.com. North Dakota Attorney General Wayne Stenehjem joins me now. Wayne, how are you doing?
I'm doing well. Thanks, Rob. Good to be with you again.
Well, I'm happy to have you on. And the reason I wanted to have you on is headlines across the state, and I'm going to read one from my colleague, John Hageman. It reads, pardons for minor marijuana crimes to be eligible for streamlined application process. Now, marijuana, we've been debating it a lot. We had the medical marijuana ballot measure in 2016, and there was a whole, legislative rigmarole that went into implementing that. And then, a lot of administrative rulemaking and all that jazz. We had a ballot measure in 2018 about recreational marijuana. Now there's a couple ballot measures coming around. And then even during the legislative session, we had debates about, decriminalizing marijuana and things like that. So just a lot of marijuana policy in general being discussed in the state of North Dakota. This streamlined application process for pardons. Where is this coming from? Is this new legislation that was passed? Is this something that already existed? What is this?
No, this is something that comes from the Pardon Advisory Board, specifically something I'd been working on. The Pardon Advisory Board is a board that advises the governor on whether to grant pardons or not. So it's not it's established by the Constitution. Actually, the governor has the authority to grant commutations, pardons, and reprieves. He has this 5-member advisory board that I've sat on now for almost 20 years, and they have the authority to adopt policies. We didn't need a statute or even go through the administrative rules process, just to look at what we thought made sense as we look at what we ought to do with pardons, is specifically in this case with possession use of marijuana.
Now, is this something specifically? I mean, is this the board reacting to what seems to be public sentiment, which is essentially we want some, I don't want to say relaxing, but I think there's a consensus in North Dakota that maybe this is an area where we could take our foot off the gas a little bit. Is that fair? Maybe I'm using the wrong metaphors.
I think that's fair. This is something actually for me that has been kind of bubbling around in my mind for a number of years. Back when I was a defense attorney up in Grand Forks, I used to represent clients who were brought into court charged with possession or use of a small amount of marijuana, and realized that even if they pled guilty, that the conviction stays on their record for a long time. That was especially problematic because Grand Forks, of course, has the University of North Dakota. There are a lot of students whose career paths require them to have a clean criminal record. And lots of different professions that caused a problem. And in addition to that, of course, we had the air base there, and that caused huge implications for people who are in the military. And I started to think, I think that our statutes ought to be reflective of the seriousness of these offenses. Then when I started here, I started as a member of the Pardon Advisory Board. Every once in a while, not often, but from time to time, we would get an application from somebody requesting a pardon, even sometimes from years and years ago, just saying that I've had problems getting a job, or it's caused problems with me getting a place to live, or even just because people felt they wanted their record clear for no other reason that they felt that they've lived a life abiding by the law, and they want their records cleared. So we typically would grant those, but I started to think, well, why should people come in and go through that lengthy, and I will say that it's a lengthy, laborious process to apply for a pardon? Why should they get a pardon and not other people who didn't go through that whole process to ask? And considering the severity of the offense, it seems to me that this is a kind of approach that makes some sense. And yes, there's been some public shift, of course, in the view of marijuana, but it seems to me that if somebody is convicted of a small offense, a relatively minor offense like this, they shouldn't have to have the burden of carrying that criminal record around with them forever.
Well,
then last session,
I'm sorry.
Go ahead.
Well, I wanted to finish your thought on last session, and then what I kind of want to walk through step by step what's changed.
Last session, the issue came up And two, in that initiated measure that was on the ballot about the question of expunging records. Well, nobody's sure what that really means, to expunge a record or to seal a record. Things aren't like they were years ago, where the court records were in a paper file and then you could just put a piece of tape over it and then the record was sealed, or expunged, you could just shred it or throw it out. Records now are digital.
Well, they hit the internet, and there's no going back then.
And there's no going back. If your name was in the newspaper, you'll find that forever, and it's there forever. It created a problem, too, with us up at the Bureau of Criminal Investigations, where we maintain these criminal records, but we maintain them in conjunction and with an agreement with the federal law enforcement agencies. So we don't have the authority just to go in and start tinkering with these and deleting things out of records that don't necessarily even belong to us. So then it seemed to me that a really smarter way than expunging and sealing and all of that talk to do it was to give people a pardon with removal of guilt, because once that is done, that will be reflected in the criminal history background check, and then after 3 years after that, then they can be completely deleted. In addition to that, if you get a pardon, what's called a pardon with removal of guilt, you can honestly say, when asked if you have ever been convicted of an offense, that you have not, and
because you've been
that
pardoned.
Is legally and correctly accurate.
Okay.
And so, and then I started looking too. I started wondering, well, how many people in the state are there that have ever been convicted of an offense like this? And I thought there might be maybe 30,000, 40,000, but it turns out we could be looking at upwards of 175 to 179,000 different individuals who have this issue. And so, of course, the pardon board's not going to go through every one of those, but in a regular fashion. But I thought that if we could put a form and put together a policy that's much less onerous than the typical pardon application that goes on for pages and pages, put together a short, concise application and tell people you will get a pardon. We'll put it on the consent agenda of the Pardon Advisory Board, as long as you have not been convicted of another offense within 5 years. And we will do that for free. A lot of states charge $100 or more for this. We can do this for free. We'll do the background check for free to make sure that people truly did not have another conviction in that 5 years, and then we'll just put it on the consent agenda. We'll look presumably through the names and send it on to the governor, who has indicated he is very supportive of this, and he will grant those pardons.
Wayne, let me walk you through, because I want to walk through this step by step so people understand what's changing. Prior, what did if you had a minor marijuana conviction, maybe like some small possession charge or something, what did this process look like under the status quo?
For a pardon? For a pardon?
For a pardon, yes.
You would have to go and fill out a form, and that form goes on, and for good reason, on serious offenses, 4 pages. They ask all kinds of things like family history, treatment history, financial situation, family relationships. They go on. It goes on for many, many pages, and it takes quite a while to fill it out. And some of that information in a matter like this is either not relevant or too onerous for people to try to bother with it. And so what this new policy does in the new application is less than a page and a half, and I think there's like 8 questions on it. Name, address, telephone number, and then the date that you were convicted and what court. And that basically is it. And then they have to certify, of course, that they have not been convicted of another offense within 5 years. And if that is found to be true, then it will go on our consent agenda for our next meeting, which is now in November. And presumably they will be granted. So it's a pretty simple, straightforward process that doesn't cost anything. You don't need a lawyer. You don't need to do anything except fill in that form. It's online. So you can fill it in online. I think you have to still print it off and mail it in, but we're even working on an electronic submission for that.
What sort of charges are we talking about? Like, what's the scope? What's the upper limit for what you can be charged with and expected to be pardoned through this process?
The charge through this process is for possession of marijuana, ingestion of marijuana, or possession of marijuana paraphernalia. So any of those marijuana usage or possession charges would be eligible.
And we're talking about 175 to 179,000. You said who would fall into that category.
It's possible that's high. Yes.
Yeah.
Now some of those are people that may be the same person who had 4 or 5 cases. So it's hard to say what the number.
Would that be a problem? Like if you've been busted for, because I know sometimes you said if you haven't been convicted of anything else, if you've been busted 5 times for possession of marijuana paraphernalia, can you get all of those pardoned, or does having more than one
for just that, and if 5 years have gone by since your last offense, that's what we would anticipate we'd do.
Wow.
And studies show that having this kind of an incentive is something that really does encourage people, incentivizes them not to commit another offense. And I would sure be concerned if I was on a career path where I worried about a criminal record. I'd make double sure that I'm staying clean with the law. And studies nationwide show that it works.
Well, I feel like across. I mean, that's a larger discussion. I feel like that's a larger philosophy that many, including yourself, are trying to implement in the criminal justice system. Is we sometimes forget that yes, these people, they commit a crime and they get punished, but most people don't get put in jail forever. I mean, most people are going to, and in this case, I'm talking about people who commit crimes serious enough to be incarcerated, but most most of them are going to get out at some point, right? And I feel like
nobody goes to prison for possession or use of marijuana. I can tell you that. We don't have anybody in jail.
Right, I'm talking about like the more broader criminal justice philosophy. It's just, I feel like just across the board, whether we're talking about minor crimes or maybe more serious crimes for which incarceration is important, it's just important to remember that we give them a path back to a responsible life again, right? Like let's clear a path so that you can go back and we're not hindering their ability to be what we want them to be, which is law-abiding, upstanding, productive members of society.
That's true enough, and of course, that process still exists. The old process for other offenses will continue to exist, or even so, you can always follow that process. And even people who may have had a little more serious drug issue can ask for a pardon. They have to go through that longer process, but they can do it, and it happens all the time.
How many pardons does this board issue in a year?
Not that many. Not that many. The ones that come to us, we don't issue pardons, of course. All we do is advise the governor who has ultimate constitutional authority. But I would say that it's less than a dozen in a year. Maybe around that amount, but it's not a whole lot.
What's the most serious crime you've ever seen?
Where people have asked for a pardon? Homicides. So we get a lot of those that are asked. We're not very lenient with those, as you can imagine, but we even get people who have had a homicide years and years ago. And sometimes there are records that people have that you do need to know about.
Do you what's the most serious you've ever seen actually pardoned?
I would have to think about that. We certainly wouldn't do it very frequently with a homicide, especially if they were intentional rather than negligent homicides. But we've seen some cases, especially where people have a job, and now with the regulations about traveling up into Canada, we see some truck drivers who've had some aggravated assaults, maybe, or simple assaults in their history, but they cannot go to Canada because that shows up when they try to enter the country. And if it's long enough ago, we will consider it. That is especially true because we always ask the victims, if there are any, for their input. We also ask the judge who sentenced the case and the prosecutor who prosecuted the case what their thoughts are on it. And sometimes they'll come in and say, yes, we think that perhaps it's time that he be relieved from this burden. And we're very sensitive to those kinds of comments.
What's the difference between this and the legislature just passed a process through which people convicted of and I guess I don't have the details off the top of my head, but you can fill me in. But it was like after 7 years, you can ask the
court to seal your record. That only seals the record in the court. It doesn't necessarily change the information that's available on a criminal background check in up at BCI. And really, more than that, what it requires is you have to file a petition with the court, which means you probably have to have a lawyer to do it. You have to set it for a hearing for the judge to consider the matter. So it's a lengthy and potentially very expensive process to go through. Some people might want to do it, but I think for these offenses, this is a simple, quick, and free way to accomplish the same thing.
Well, yeah, for sure. Do you expect? I mean, when does this? I mean, is this something people can do now? I mean, has this gone into effect?
Yes, it's if you go to the Department of Corrections website, the application form is online. The policy was adopted yesterday by the Pardon Advisory Board, and so it's something you can fill out now. There's no deadline. You can file your application anytime that you want to, but there is a deadline for consideration of the matter at the next meeting of the Pardon Board, which is in November. And that's just because there's processing we'll have to go through, and
sure.
we'll have to
But basically you get it in at any time. Once the processing's done, it'll be taken up at the next available meeting. That's kind of how it works.
Yes, and I also suggested, and the Pardon Board agreed, that if we have a whole lot of these, there's no reason we can't have a special meeting just to consider these applications that have come in, because they'll be relatively quick and straightforward and probably won't take very long. But at the same time, I just don't know how many people might be interested in applying. I just have no idea. I have a rough idea of how many potentials there are, but how many might feel that they want to avail themselves of this is just something I'm not aware of, and we'll find out, I guess, in a few weeks.
Well, we will, but I think it's a good step in the right direction. I really do. I don't know that you and I entirely agree about what our laws should be on whether or not marijuana itself should be illegal, but I think at least on this end of it, this is a good way to maybe help people, like I said, have a path back to a productive life.
Well, I think that's true, and I guess we probably don't agree, maybe not as much as you think, but I do think that the penalties need to be proportionate to the offense, and the length of time that you have to haul around a conviction like this when there are so many really needs to be limited, and this is designed to do it, and I hope that people will be aware and get their applications in, and we'll see how it works.
Wayne, thanks for your call.
My pleasure, Rob. Anytime.
That's it for today's Plain Talk podcast. If you want to follow the podcast, there's lots of different ways. All the different podcasting apps, just search for Plain Talk. It should be accessible. If you're having trouble with one platform or another, email me, rob@sayanythingblog.com. I'd be happy to help you out. You can also use that email address if you have questions for our weekly guests or any other feedback on the show. Our weekly guests, of course, Senator Kevin Cramer, Congressman Kelly Armstrong. We always have a good selection of questions every week for them when they're on the show, so I really appreciate that. Follow me on social media, Facebook, Twitter. Just search for Rob Porter, Say Anything Blog. You'll find it, and thanks for listening. I appreciate it. We'll talk again.